What's going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. All right, I've got a very interesting one today. This is out of a court that I just started watching a week or two ago. I know I've covered this judge at least once, if not twice. Yeah, he's not playing games with this defendant, and this defendant was already sentenced to jail, and somehow he got out of it. You're going to hear how he did it, and yeah, the excuses come out. All right, before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Next case the court's going to take up will be State of North Dakota versus Wesley Lawrence Allender, file 37-2022 CR 83. Present in court for the state, Attorney Fallon Kelly. Present in court by reliable electronic means. Ms. Chisholm, are you present?
Yes, I am, Your Honor.
Ms. Chisholm appears by reliable electronic means with the court's permission. Mr. Allender appears personally in court. In this case, we had a jury trial. The court sentenced the defendant. The defendant appealed. The Supreme Court affirmed. The mandate has been returned. Mr. Allender was sentenced to serve 6 months in jail. Mr. Allender had some medical or psychiatric issues that were addressed when he was taken into custody. He was then released from jail. He is not returned to jail to serve his remaining 6 months of sentence. Mr. Allender and his attorney did not file a motion to stay the jail sentence pending the appeal. No stay has been issued. There was a Rule 35 that was filed before the appeal requesting a different sentence, and the court rejected that. So, Mr. Kelly, go ahead.
Your Honor, it appears that the defendant should start his sentence, and he should probably start it today or very soon after today.
So, Mr. Kelly, why didn't you bring the motion immediately when he didn't serve a sentence and didn't file a motion for a stay pending appeal?
Simply because appeal was pending, Your Honor.
Anything else, Mr. Kelly?
No, Your Honor.
Ms. Chisholm?
Thank you, Your Honor. And as the court is aware, I was not Mr. Allender's attorney at the time of his appeal. However, with that being stated, I would note that Mr. Allender has made arrangements and been very proactive. If the court were to consider allowing Mr. Allender to serve his jail sentence at a mental health facility, we have been in touch with Rachel from the VA. Mr. Allender has made arrangements at a facility in St. Cloud, Minnesota. There is a bed available. He would have the opportunity to serve out the remainder of the jail sentence there if the court would allow him to do so.
So, Ms. Chisholm, what's the reason that he didn't self-report back to the jail? So you said that he's...
Your Honor, I would defer to Mr. Allender to explain to the court why he did not. I would assume it has to do with his mental health issues, Your Honor, but I'll allow Mr. Allender to explain to the court if the court would allow him to do so.
And so, Ms. Chisholm, you're saying that there's a bed available for him at the St. Cloud VA right now?
That's correct, Your Honor.
My understanding of the St. Cloud VA and their mental health program or their dual diagnosis program is that it's a 30 to 45-day program, not a 6-month program. Are you saying that the VA will house him in a locked facility for 6 months?
I don't know the length of the program. However, it sounded as though it was up to 90 days, and I don't know that it's a secure facility, Your Honor.
So the sentence was for 6 months. And I think he served 2 days, 2 or 3 days at most, between his time in Barnes County and his time at the state hospital before the state hospital cleared him for psychiatric reasons and tried to send him back to Barnes County. So what are we going to do if the St. Cloud program is only 90 days, it's unlocked, and it's not consistent with the court sentence? The court at this time doesn't have jurisdiction under Rule 35 to reduce the sentence. That time frame is 120 days following the completion of, or following the judgment. We're well beyond that. Where does that leave us?
All right, real quick. Rule 35 is a motion you can file to ask the court for a reduced sentence. I don't know the intricacies of it, but that's kind of the high view of what Rule 35 is. Also, a little bit of a warning, I guess. I don't know what he was charged with. They don't talk about what he was actually charged with, the crimes that he was convicted of. They did say he had a jury trial and he was sentenced to 6 months. And after 2 or 3 days of being in jail, they released him. And yeah, he was supposed to go back. He didn't.
So
That was, unfortunately, Your Honor, Mr. Allender would have to return to jail upon completion of any inpatient program.
Mr. Allender,
Yes, sir.
why didn't you go to jail?
I have mental health problems and I'm medicated, but they can't support my medication in jail. And when I'm alone, I have bad thoughts. I've had them for a while. Very bad self-harming. I've been under safety plans through my family, through my children, my safety dog, my mom, to keep me safe. I don't go anywhere alone. Could I please ask for at least house arrest or something so I can continue my VA program through the telehealth, and my kids just lost their grandfather about 2 weeks ago. He was hit by a semi, and we're all having a really, really hard time with that. I'm just asking for some mercy, and I need to be there for them. I understand that I need to serve my time, but if I could please serve it at house arrest or treatment facility. You can put me on an ankle monitor through a treatment facility. I don't care. I mean, I need to be able to be there for my kids, and I need to be right in the head to be able to be there for them.
So, Mr. Allender, here's my issue. And it's not just my issue. We had a trial. You were found guilty by a jury of your peers. Mr. Kelly at that time asked for a maximum sentence.
Yes, sir.
I listened to the same arguments that you're making now then. I ruled and sentenced you to a substantially less time than what Mr. Kelly was advocating for. It was half as much time as what Mr. Kelly asked for.
I understand, sir.
You at that time claimed the same thing, the mental health problems then that you do now.
They haven't gone away, sir.
Stop talking.
Sorry.
Bulky important instructions would be announced.
So the court considered those arguments at the time. court weighed them against the sentencing factors that were required for the court to consider under North Dakota Century Code Section 12.13204. The court discounted the sentence that was being advocated for, not just by Mr. Kelly, but by the victims' families that were also asking for a maximum penalty. And so not only did I dismiss certain charges against you based on the motion practice, I gave you half the sentence that was being advocated for by the families of the victims and by Mr. Kelly. You went to jail. You claimed that you were going to self-harm in jail. The jail sent you off for an evaluation. The evaluator came back saying that you were saying those things in order to manipulate the sentence. And then after that, the jail wouldn't take you back. And then you didn't go back to jail. You didn't go to St. Cloud. You didn't go to a mental health treatment facility at that time. You continued to remain out. And I'm talking. So by being proactive, you appealed. You didn't file a motion to stay the sentence pending the appeal. You just continued to operate in the community as though nothing happened. And it did. You didn't follow the court's order. Mr. Kelly didn't file a motion to revoke your probation and to have you resentenced. He could have. Mr. Kelly hasn't charged you with another crime for disobedience of a judicial order. He could have. Mr. Kelly didn't charge you with an escape. He could have. And so where we're at right now is no different than we were at sentencing. It's no different than we were when you filed your motion for Rule 35, and the court rejected it at that point in light of the societal concerns. And again, the court considered all of the arguments before. So we're in the same place now that we were. I'm hearing the same arguments now, and nothing has changed.
I don't understand what this stay thing is that I should have filed, or who should have filed it, because I didn't have an attorney as far as I knew at the time, and I'm not an attorney, and I don't know what I'm supposed to do.
So you had two attorneys. You had.
All right. So now you guys have an idea of what's going on. He was sentenced to 6 months. He served 2 or 3 days. He threatened self-harm, so they sent him to a psych ward, and then they just released him. Kind of interesting. And the jail wouldn't take him back. So he was out. They released him way before his 6 months. Don't really understand how that works. That doesn't really make sense how that happened. If anyone can clear that up for me, I would appreciate it. Also, yeah, he could absolutely be charged with escape. He didn't go back. But if they say the jail wouldn't take him, there's a lot of confusing things in this. But this one's interesting. I told you.
At that point, you had Mr. Christine. And then on appeal, you had a different attorney. It wasn't Mr. Christine on appeal. It was Ms. Genderick, if I recall correctly. But nevertheless,
I didn't know anything about it, sir.
Well, you certainly knew that I sentenced you to 6 months in jail.
Yes, but I knew
again
nothing about having to report back.
Stop talking.
Sorry.
You knew that I sentenced you to 6 months in jail.
Yes.
And you knew you didn't serve the 6 months in jail. You knew you were supposed to be in jail, right? And all of that stuff was well within your knowledge. I don't find credible that you didn't know that you needed to be in jail. And you didn't take those steps to return yourself to jail. And so where that leaves me is you got 6 months in jail to do. I understand that your family is going through a hard time.
There's no way to do house arrest.
Again, stop talking.
Sorry.
You requested house arrest before. I rejected it. You requested house arrest in the Rule 35. I rejected it. I'm not going to change my mind, Mr. Allender. Frankly, at this point, I don't have jurisdiction to change my mind and to lessen the sentence. I can't do that now. So we're already past the time.
I was actually wondering that. Can he change the sentence if he wanted to? I was gonna say I don't think he can. Yeah, I don't know. Again, I need help with clarification. So for everyone listening, drop a comment if you understand what's going on.
To file a Rule 35, you've already done that. I've already rejected. I can't change the sentence in a downward motion at this point. I can change it going upward. I'm not going to do that, but I am going to require you to serve your sentence. And I'm going to require that to start right now. So you will report, and Mr. Benoist will take you into custody today. It's up to him on whether or not he's going to allow it, because you were sentenced to the sheriff's custody. He can place you wherever he wants. If he feels comfortable with placing you at a place like the St. Cloud VA for your mental health, I'm not going to prohibit him from doing so, but it's entirely up to Sheriff Benoist on where he places you. You're in his custody. And so if that means jail, that means jail. If that means at the VA, that's up to him, but I'm aware that that VA facility is unlocked. I'm aware that the program does not last as long as the court sentence. I'm aware that society expects me to follow through with the sentences that I've imposed. And what would it look like to change my mind now? And after all of those things that you knew about and didn't follow through with, if I cut you a break now and just said, it's okay, go on house arrest. That's me not following through with the promises I made, not only to you, but to follow the law and to apply it in a reasonable, even-handed matter. And it would be doing the victims disservice if I did that now. I understand you're dealing with a lot. I don't expect that's going to change. And those are things that I already considered when I gave you half as much time as what Mr. Kelly and the victims were asking for. And those are things that were taken into account before. So that's the court's order. I'm frankly disappointed that you weren't after you were cleared. I'm disappointed that the jails in this district didn't accept you, because that was the court's order. I expressed that in my Rule 35 motion in that order, that it would be categorically inappropriate for any defendant, not talking about just you, but if anyone said, I have mental health concerns, so jail, you can't jail me. And it would be inappropriate for the jail to just say, oh yeah, well, that person says they have mental health concerns, so we're not going to accept them.
All right, I was going to make that comment too. If the judge did for some reason overturn this and like, oh yeah, you can do house arrest, there would be every person in jail would start claiming mental health issues and saying, I'm going to self-harm. Nah, doesn't work that way. I'm glad the judges standing up for this. And again, I could see no reason why he wouldn't. All right, I'm going to let this video play out. Told you it was interesting. Hope you guys have a great rest of your day. If you haven't done that already, please hit the like button. Until next time, bye.
I think that would result in defendants manipulating jail sentences all the time. And so that would set a horrible precedent. I can't allow that, because my job is to uphold the law and to enforce the law and to apply it reasonably and even-handedly and fairly. And I think that happened during your trial. I think that happened at sentencing. And I think that happened in all the proceedings after that. I understand you disagree with the result. Not a lot of defendants agree with the results that I hand out. That's part of my job. But that's the court's order, is the sentence that was imposed will be enforced. It's up to the sheriff on where he places you and what facility. That to me is something that's in his discretion. I've put you in his custody. So you need to follow what the sheriff is going to tell you. But my sentence is 6 months in his custody, followed by probation.
Yes, sir.
All right. Anything else, Mr. Kelly?
No, Your Honor.
Anything else, Ms. Chisholm?
No, Your Honor. Thank you.
With that, we're adjourned. Thank you.